You are listening to Divorce for Men Radio, brought to you by Goldberg Jones. I'm Rick Jones, and I'll be your host as we discuss legal topics and issues related to divorce and custody that husbands and fathers often face. Before we get started, let me take just a moment to tell you about Goldberg Jones. Founded 17 years ago, we've become a premier family law firm on the West Coast and the original Divorce for Men resource. We've protected the rights of thousands of men just like you who desire to be treated fairly when it comes to their children and their financial future. Our goal in creating Divorce for Men Radio is to provide valuable information and interesting discussion that answers questions you might have about family law. Remember, we're always able to answer your questions personally and at no charge by calling 1-800-DIVORCE or finding us online at goldbergjones.com. All right, let's get this started. With me today is Ken Allen. Ken, welcome to Divorce for Men Radio.
Great. Thanks for having me.
Ken Allen is someone you'll want to know if you're a man in need of divorce or custody-related help in the greater Seattle area. Why is that, Ken?
Well, I'm the managing attorney of the Seattle office, and we've been practicing family law here in Seattle for 17 years. We've got 12 attorneys that exclusively practice family law and mostly representing men. So this is what we focus on, what we know, what we do on a day in and day out basis.
How can prospective clients reach you directly?
Well, the easiest way is pick up the phone, call me at the 1-800-DIVORCE number, or you can reach me online at goldbergjones.com.
Terrific. Is there a best time to reach you?
Our office hours are Monday through Friday from 8 to 5:30, so that's the best time. Even if you can't get a hold of me directly, you can certainly leave a message, and I should be able to get back to you within a couple of hours at the latest. Even on the weekends, if you want to go ahead and email, I have access to email over the weekends and can oftentimes get back even on the weekend to you.
Where's the office located?
We're on the north end of downtown Seattle, right on Lake Union. We also service King, Pierce, and Snohomish County.
We're back on Divorce for Men Radio. I'm Rick Jones. I'm here with Ken Allen, managing attorney of Goldberg Jones, Seattle. Ken, I want to turn your attention to another issue commonly faced by many of our clients, and it's related to child support, but a little bit different. It's called post-secondary educational support. First of all, can you tell us what that means?
Well, yeah, oftentimes most people think that, well, my child support or my obligation to my minor child would end when the child turns 18 or graduates from college. Well, not necessarily so. In Washington, there is a post-secondary education statute, or basically college expenses, where the court can step in and order the parents to contribute towards the child's college expenses.
So above and beyond child support or after child support terminates?
They basically have to bring the action while the court still has authority over the child. So generally these actions are filed prior to the child graduating or turning 18 for the court to be able to step in. Otherwise, you basically have an adult that the court's trying to order obligations for.
So I do find that a little bit odd, Ken, because you're describing that the court has the ability to establish a requirement that parents provide financial support for college expenses for a child when they've divorced. But two parents still living together, still presumably happily married, the court has no authority to come in and order that. Is that the way you read it?
It's pretty much like that. It's actually extremely interesting. And even further than that, Rick, is you basically have an adult child. Let's say they're 18 and they're a senior in high school. They're picking where they want to go, what they want to do, what their college education is going to look like. Yet they, in a roundabout way, have the ability through one of the parents to obligate the other parent to pay for their college. So the tough part about it is they get to make that choice. For example, let's say child says, I'm going to choose to go to, party school A. And a normal married couple could say, well, we're not going to fund party school A. We'd rather you go to this more educational school B. Well,
by party school A, you mean Washington State?
Yes, that's exactly, because I'm a UW grad. But so now what happens? You've taken this ability away to make a choice, and so from a married couple's perspective, they can come in and say, hey, I think you ought to work through school. I think you ought to do this. Maybe community college is a choice for you. From a divorced family, it actually works the opposite, where the court can now step in, and the child has the authority to make these decisions and again obligate a parent to pay. It can be extremely frustrating, especially for parents. Let's say a father who hasn't had much contact with the child or hasn't been that involved with the child. And now, after child support's supposed to end, this child comes in and says, continue to pay, continue to help me forward get through college without having any say whatsoever in that decision.
Now, is this post-secondary educational expense a requirement, or is it something that can be contested?
It's not. Fortunately not. It's not child support. It's not an obligated thing. It's done on a case-by-case basis. So there is a lot of ability to come in and say, well, let's take a look at this. And what is the child's aptitude, what one party's financial situation is versus the other. So there's a lot of ability to come in and tweak that, narrow that down. It's not something like child support where it's purely based on income.
One of the interesting things I know I've found regarding the post-secondary support issue is that we're dealing with our clients, fathers who have been proudly paying child support for years and years and years. And there's a silver lining on this, which is they often have come in fully expecting to be able to provide what they can in terms of educational support ongoing to their child. And this actually provides an opportunity to have the other parent obligated for a change. How does that work? If there are post-secondary expense requirements, who are those paid to?
Generally, it's paid to the institution if at all possible. So you're absolutely right, Rick. You can, as a parent, come in, and it's not just paid to the mom in this example. Payments are not generally paid to the primary parent. Again, it's not child support anymore. So the other parent does have an obligation, and it's paid directly to the institution. So that is kind of nice. They can come in and say, look, you need to help contribute as well.
Ken, as always, thank you. I'm sure there's many questions remaining about post-secondary education expenses and what sort of obligations can be incurred. How can somebody reach out to you?
Call me directly at 1-800-DIVORCE or find me online at goldbergjones-wa.com.
You've been listening to Divorce for Men Radio, brought to you by Goldberg Jones.